They're all just down through YouTube. At work. Yeah, I don't try that work. I don't try that work, just watch it at home.
I can't just access it on my own laptop.
Yeah, it's just on YouTube.
Oh, the whole video you can get wherever you want.
It's just online.
It's just through work.
No, it's all online. That's why I can access it. That's why we can work on it here. I could call up VLE here if I wanted to.
I just thought it.
No, it's just a web platform. It's an online. Well, it's a website, the VLE. So you should be able to access everything that's got, and that's got the study guide on it. And everything else, yeah. Right. So the Children, Guernsey and Alderney Law 2008. It's very big. So you need to know about that law. And you need to know probably that its roots are a bit Scottish, so it's got similarities with English law because the concepts are similar, but it's not exactly the same. So if you look at an English textbook or English cases, they're not going to look identical. You also have procedure rules. You have children rules, which deal with children-related stuff. So you need to be reasonably familiar with them, and it is worth getting hold of a copy of those. So they're the Family Proceedings Rules 2009, and you've got some practice directions. Now, your children law did not come into force until January 2010, which is relatively late, I suppose. Its principal purpose, we're told, was to reform the law. So this was, as it was in England, reforming legislation. It had an aim, which was to try to promote the welfare of children and their families. A child is anybody under the age of 18. There are some, if you're married, for example, at 16, for many purposes, you're no longer technically a child. So what does the law try and do? Well, it wants to protect children from harm. So that's the child protection element of it. And it wants to actively promote their health, welfare and development. So the law tries to achieve the best it can for kids and protect them when they're at risk. It's those two aims, and to put responsibility onto parents where it can. Unusually, because you wouldn't find this in the English law, the children law actually creates and explains, which is one of the reasons you're probably going to need to read the thing, new tribunals and people, bodies, offices to carry out the functions that were required under the law. So it set up the children's convener. And the convener's job, as far as I could understand it, is to investigate cases where there are concerns about children and to refer cases to the Child, Youth and Community Tribunal, which is a tribunal which deals with some children's cases, and they are a lawyer, as I understand it. Is it just one person? Have you only got one convener? Yeah. Okay. Then you have a safeguarder service, which is now known as FPAS. Catchy title, Family Proceedings Advisory Service. FPAS, that makes sense. In Jersey, they are JAFPAS, Court Advisory Service, Jersey Court Advisory Service. So you've got FPAS, that's fine. If you see references to the Safeguarder Service, they are the same thing. Used to be known as the Court Welfare Service, which is what it was called in Jersey in historical times as well. And their job is to safeguard and promote the welfare of children by advising the court and the convener. So they're sort of, certainly in Jersey, there tend to be specialist social workers who've worked children's cases. In Jersey, they actually sit under the probation department for some weird wonderful reason, but they are social workers, children's social workers. Then you've got two essentially courts that were set up specially to deal with kids. The Child, Youth and Community Tribunal, which is a tribunal of lay people, so it has no lawyers on it, doesn't have a professional judge. And the Juvenile Court, which is the magistrate. Is the magistrate actually Cherry? Yeah, I thought so. Okay. It's difficult to identify who these people actually are from the stuff that you can find out.
Yeah.
but I sort of assumed it was Cherry. So I say here, it's a one-stop shop. It's meant to set out what the duties and powers are of people, generally where they're in charge of children, and the state. Okay, so when it has to step in to protect children and what support it has to provide. It provides a framework for sorting out arguments within the family as to what should happen with children. We tend to call that private law, and between children, well, where children are the subject of concerns by the state and intervention by the state, we tend to call that public law. Okay. Children law has at its heart a number of key principles, I say, designed to guide the court in exercising what are discretionary and draconian powers. They have to be discretionary because the court has to be able to achieve a solution which fits a particular child in particular circumstances, which means you have to give the court a lot of flexibility. But you don't want them to get it wrong, and you don't want them to run through the human rights law. You want them to observe human rights principles. So to try and make sure they A, get the right answer, and B, are human rights compliant, you give them principles and checklists that they have to apply. The idea being that if they follow the route given to them by the law, the judge will get the answer right, or at least won't get it wrong. And a lot of those principles apply to both the private stuff and the public stuff. Why is the role of lawyers particularly important? Well, these are life-changing proceedings for children. So the way that these proceedings go, whether it's who they live with and who they have contact with, or whether it's being taken into the care of the state or adopted away from the family, those decisions are going to have lifelong impacts on children. So it's important we do our job properly, because actually if we don't, the judge can't. The judge will only know what lawyers tell him or her. And that's why things like domestic violence are so important, for example, because if the judge doesn't have that information, they can't properly exercise that discretion. And sometimes neither can the advisory service. The role of counsel, good one for an ethical point. What is the role of counsel in proceedings generally, but particularly in family proceedings? In the matter of C, this was the court chucking a bit of a fit at lawyers for being unhelpful. Judges do not like lawyers who allow them to drift into error, who don't correct them, and who don't say to them when they hand out draft judgments, "Excuse me, sir, but I think this is a bit squirrely. Can you explain what you've done here, please?" And instead sit back and take it to appeal. They do not like people doing that because it's embarrassing for the judges, and it means that a judge has fallen into error potentially, which could have had serious consequences for a child. So the court takes very seriously the overriding objective, and we'll see what that is. That's within your rules. There's a similar provision in England and in Jersey, which tells the court that the overriding objective is to enable the court to deal with cases justly. But parties are required to help the court to do that. That's specifically within your rules, and that unfortunately includes counsel. Where parties are represented by counsel, it is your duty to assist the court and to draw attention to anything that needs to be highlighted. So you are expected to know enough about the law to be able to flag with the court anything that is relevant to the job that the court is doing. There were several counsel in attendance when the juvenile court's judgment was delivered, and the convener appeared in person, which of course also a lawyer. It's most unfortunate none of them asked the judge if she had missed something out. So very important that you understand the role of counsel in children's cases, which is to be as helpful as possible to the court. And that's an ethical point, if you like. The welfare principle is one of those principles which sits like an umbrella on the top of both private law and public law. Throughout Britain, it is a central concept to our law. Okay, so you'll find it in England expressed slightly differently. You'll find it in Jersey and elsewhere. We talk about the welfare of the child. And that's because it's something that runs through British law from at least the Middle Ages, but probably earlier than that, through concepts like wardship, where people used to take on wards who they protected. The English courts said, this is back in 1977, rather like, you know, the presumption of innocence is the golden thread that runs through British justice, that kind of nonsense, like criminal law. What the court said about family law is that the welfare of the child is the golden thread which runs through the wardship jurisdiction. It is the welfare of the child which is considered first, last, and all the time. Okay. Now that's from 1977, so well before your law came in, well before the English law. But all it is a statement of this principle which has grown up since medieval times in Britain, that where we are dealing with children, they come first, absolutely first, above all, and they are the only consideration, the only thing we worry about. That is still a feature of our law. Other jurisdictions are slightly different. Other jurisdictions give more power, actually, to the decisions that parents can make their children, which is why if you follow these kind of cases, don't know if you remember the case of Charlie Gard, the baby where they switched off his life support. The reason the rest of the world went bonkers is because they couldn't understand why legal jurisdiction would say, sorry parents, we don't agree with you wanting to keep your baby alive, we're going to switch him off. And they could not get their heads around the fact that what was perceived to be in the welfare of the child, which in this case included withdrawing life support from him, was seen to override the wishes of his parents, who were not permitted, even when they had the money to pay for it privately, to keep that child alive, because it was not considered in his best interest to do that. And the fact that the court had the power to make that decision based on the way the British understand the welfare principle actually scared the life out of, in particular, the Americans. They just did not get it. It's a central thing that's run through British family law for many, many centuries. So how does that translate into modern times? Well, any law, whether it was the English or the Jersey law or your law, was going to have to find a way to encompass that principle. And set it out in a statute. Your law does it slightly differently to Jersey law, okay, in that it's more detailed. But what it boils down to is that the child comes first. The child is the only consideration. Parents are important, but actually we don't really care what's best for them. We care about what's best for the child. So the overriding principle that underpins the legislation is that child's welfare is the paramount consideration. And that's in section 3, okay, of the law. That's not the case when we're talking about money. When we're talking about money, children are just the first consideration. Paramount consideration is a higher test. It puts them really on a pedestal. When we're dealing with money, kids come first, and that's fine. But when we're involved with decisions for children under the children law, children are the only thing we're concerned with. We don't really care too much about their parents, provided we act in a way that's human rights compliant. You have in your law 11 child welfare principles, okay? A lot more detailed than we have in England or Jersey. So you're lucky in that the law of Guernsey actually tells you what welfare looks like in quite a concrete way. And notice the day-to-day fairly ordinary language that the statute uses. Child's welfare is normally best served by being brought up by its family in its own community. So again, that principle of pushing the care of children onto the family supported by the state. Where it's not possible, its welfare is best served by having regular contact with its family and community. The principle that where a child can't live with its family, it should have that sense of identity with its family and contact with it. There shall be no compulsory intervention by the state unless it is necessary for the child's care, protection, guidance or control. And you'll see that repeated in the relevant parts of the law. It's basically a hands-off unless you have met a threshold, a bar, a level, which is serious enough to justify you coming into the lives of this family. Because otherwise it ain't your business. It's for them to parent their kids, not you. And there are a lot of cases in England which talk about the fact that we have to be prepared to permit understand that there are diverse standards of parenting, that there is nothing wrong with that, and that even if we happen to think that other people's moral standards are not good enough, that does not mean they are not good enough parents. We are not in the business of social engineering by removing kids and putting them in nice families. Delay is prejudicial to a child's welfare. What that basically means is that where proceedings are going to be brought, they should be brought as quickly as possible. The cases should not run on forever, and they should not be adjourned countless times because people aren't ready. That does mean that there are quite tight time limits normally imposed within children proceedings for getting on with it. A child should be given the opportunity to express its wishes. We know not now, or we hear a lot about the voice of the child, okay? So in other words, whereas 20 or 30 years ago, we might have sat here and said, look, teenage person, we know best for you. We know what's good for you. We know best. We'll tell you what the outcome of this is. Children are much more involved in their own cases now because it's their life we're dealing with.
There must be some interaction with parental alienation that you mentioned earlier. Does that sort of have a part to play?
Well, there are two sides to that. One is that certainly children will always be asked what they think, always. Now, the problem with parental alienation is if you ask a child who has been subjected to that, what should they think? They are going to say, my dad is evil, my dad is an X, Y, and Z, I never want to see my dad is bad, my dad is a bad man, because that's the kind of thing they tend to say. So listening to the voice of the child, whilst important, cannot be always overriding, because children can be influenced by adults, and we need to be careful that the voice we are hearing is the voice of the child and not the voice of an adult with an agenda. Okay, and it's sometimes quite hard to distinguish between the two. That is one of the difficult roles of FPAS, to understand and interpret the actual, what the child is really saying. And they will make assumptions about that. We assume that children, generally speaking, want a good relationship with both their parents. Generally. We assume in the case of babies who can't express their wishes, or young children, that they want to be loved and to have a nice, warm, safe upbringing in a stable home. Okay, but they're assumptions. One of the differences between Guernsey law and English law, and one of the similarities to Scottish law, is that you attach particular significance to the age of 12. Okay, your law says, unless shown otherwise, a child is capable of forming a considered view when it is 12 years of age. Now, it doesn't mean it gets to pick just because it's 12. It doesn't mean it gets to come up with its own solution, because if you ask most 13-year-olds how much homework they want to do, they're going to pick the household that has the less homework. Let's face it, they do not always make the best decisions for themselves. But when it comes to attaching weight to what a child wants or thinks, you are going to form the view, unless you can prove otherwise, that they formed a considered view, so they know, understand, and are expressing a fairly grown-up opinion about what they think should happen in their lives. Now, what that means is that the older a child is, the more influence their wishes are going to have on the outcome of the case, almost inevitably. That does not mean that kids always know what is good for them, because they don't. All children love their parents, including abusive ones. Even very bad parents have children who love them. A child in state care should be entitled to the same level of care as would be provided by reasonable parents. Now, if they can achieve that, that's amazing, because the anticipated outcomes for children in care are very poor in Britain. They are far more likely to enter the criminal justice system. They are far less likely to do well at school. They're far less likely to be economically well off later on in age. They're more likely to be depressed. They're more likely to have serious difficulties. And that's partly why before we put a child in the care of the state, we have to be very sure that we're offering them something better than they're getting at home, because it is not ideal. Where a case involves criminal activity, the focus of compulsory intervention should be on the prevention of that activity in the short and long term. A lot of public law cases with older children, for example, involve those children committing offences. They tend to be misbehaving badly and getting into trouble with the police. So we try not to criminalise that behaviour if we can avoid it, but to look at how we can change their world so that they are less inclined to act in that way in the first place. So we don't necessarily regard the criminal law as being a solution to a problem, because it rarely is. Parents, and this is great, if you've ever had instructions from divorcing parents, you try telling them that this is what they've got to do. Parents and others responsible for a child's welfare, grandparents for example, are expected to consult, cooperate, and to resolve matters by agreement where possible. The idea is that most parents should be able to settle arrangements for their kids without the intervention of a judge, and that is true, they should. Because at the end of the day, parents know their kids, love their kids, and are far better placed to make decisions for their children than judges are who have never met them. They're far more likely to get it right, actually. But in order to do that, they have to be able to cooperate. What does that mean from your point of view? Well, you have to encourage your clients, provided it's safe, and that comes a little bit back to domestic violence and stuff like that, to talk to the other parent and to form a constructive cooperation with them to try to resolve arrangements, because they're going to be the Brady Bunch in a few years' time, apparently. It really is that easy. Every now and again, you get parents who are very good at it. Every now and again. You get parents who are very good at it. Not normally immediately after they separate. It is generally in the interest of a child to have contact with both parents, and the parents and the state must promote that contact. This was to give a very firm message, and it's a message that's come out from courts really across Britain and legislation across Britain, to those who think it is not in a child's best interest to continue to have contact with classically its father after a divorce. A very clear message that that is wrong, that children need to retain a relationship with both their parents. And one of the hardest jobs as a family lawyer is often to convince generally mothers that they need to let their child go for contact, that it is not in the child's best interest to spend very little time with their father on the basis that either he doesn't deserve it or they're fine as they are. Classic things that you hear.
If one parent didn't want, just if they walk away, didn't want anything to do with children, how would the court deal with that?
You cannot force someone to have contact. What we're told when we do mediation training and things like that is to explore with the father why they think, what reached them to that conclusion. A lot of the time they will tell you, I think it's best for the kid that it knows where it is, and it will just get confused if I'm in and out of its life. And sometimes you have to explain to them that that's not actually right, that children post-divorce do far better if they have regular contact with both their parents. That disappearing from their lives is not a good thing for any child, generally speaking. And a lot of dads will also, when asked, say, I'll just, when things have calmed down a bit, I'll re-establish contact and we'll be fine when they're older. And that doesn't happen. Where there is a lengthy break in contact, in a lot, if not most of cases, it will come home. They don't tend to, children do not form. Once you've let that contact go, it's very, very difficult to re-establish it. So quite often, once you've had that discussion with them, they're more interested in establishing contact with their child.
But it's your role, if that was your client, you have to really explore why.
Yeah.
Why you don't want to see, you've got 3 daughters, why don't you want to see them?
Yeah, but see that.
Well, no, I was just thinking it. I was just wondering whether it's because you can't force.
I have had clients who have said that they won't pursue contact, and normally it's because they've been the one who've left. They feel guilty. Their ex-wife or their wife is resistant to that contact. and they think it will just be easier and better for everyone if they don't have to fight and if they just walk away, and they'll come back later when everything's calmed down. And once you've explained to them that, you know, children really do benefit from having both parents in their lives, and that it might be quite difficult to re-establish that contact later, they tend to start to think about it differently.
If you advise that the court thinks
Absolutely.
it's
Yeah.
best that both parents
And you can
are
say it
involved.
quite forcefully. You can say, we know that children do better when they have both parents in their lives. We know that. Because we've been studying it for quite a long time. And most of them will come around to that way of thinking. Men are also, I would say in particular, men are quite good at sticking their head in the sand. And they'll sort of not do anything about it for a while in terms of seeing their kids. And before they know it, they've not done anything about it for a year. And then it's difficult to do anything about it at all. And quite a lot of the time, that's been the pattern of the contact. It's just sort of died. And that's quite hard to re-establish. But it does happen, sadly. It does happen. There shall be no discrimination on the basis of gender, marital status, or other listed protected characteristics. Quite commonly, dads will say to you, is she definitely going to win because she's a woman? And the only correct answer you can give is no. The law does not discriminate between men and women. The law does recognise the important role of primary carers, which is the same way generally as saying that the law can sometimes look like it favours women. Because men often feel they don't get a fair crack of the whip when it comes to kids. Decreasingly, I hope. And certainly, I don't know what it's like in Guernsey, in Jersey, we're increasingly seeing shared care arrangements. I don't know how often you get that here, where children are spending fairly equal amounts of time with their mum and their dad after divorce. Partly because a lot of women are now working, so people are sharing the childcare essentially.
Yeah, if you put an application for a shared residence order, it's, you know, it should reflect that the child has two homes.
Yeah.
One with the mother. I mean, that is how it is. Even if you've got your interim contact, it's still one home, two home, both other children.
Yeah. And that's there are two reasons in law for a shared, what you used to call residence order, for a shared home order where children are living with both parents. So they have two places they consider home. They will generally say when asked, well, I've got two homes, or my mum or my dad. So one reason for giving a shared care order is because it reflects life on the ground, as the way the judges put it. It is what is happening. And the other reason for doing it is where it's in the welfare of the child for some other reason. Sometimes parents go to war. And in those cases where they cannot communicate, where one is trying to completely undermine the other, or quite often they're undermining each other at the same time, sometimes the solution to that, to stop one parent from queening it over the other, often a mum, as treating dad as having some kind of second-class role in the child's life, the answer to that is sometimes a shared residence order, even where the split of time is not equal. So those are the two sort of main reasons for making shared residence arrangements.
Does it impact maintenance as well?
It does on a practical level. It doesn't mean there isn't any. It shouldn't mean that there isn't any. It does mean that we take into account when we're looking at how much maintenance someone pays, we take into account what the arrangements are. So if you've got two parents who have broadly similar incomes, it could be that you won't have any child maintenance. If you've got parents where one's earning a lot more than the other, then there probably will be some child maintenance, but perhaps not as much as there would have been if the child was living full-time with the other parent. And the CSA guidelines, the Child Support Agency guidelines, do actually build in that sort of shared care discount almost. Depends on whether there's a disparity. Okay, so the welfare principles apply to almost every function exercised by a public authority. That includes courts. Okay, so when a court is considering the life of a child and the upbringing of a child, they have to apply these welfare principles. But so does everybody else, every public authority, so schools, hospitals, doctors, whatever, have to be applying these principles when they're dealing with children. Unless compliance gives rise to a risk to health and safety, where the court's considering the variation of a trust, because basically if a court varying a trust had to make the children paramount, that would be a complicating factor in many trust applications. Or where the function of a state body is a decision relating to the prosecution of an offence. Okay. So the Attorney General doesn't have to look at the welfare principle necessarily when deciding whether to prosecute someone. In the matter of C, 2013, so that's the same case. Okay. Again, a number of sort of leading cases, a relatively small number. This was an appeal from the Juvenile Court, which was sitting as an appellate court following a hearing in the Child, Youth and Community Tribunal. It can only hear appeals on a point of law. One of the things to get clear in your head, whichever area of law you're studying for the exams, is where the roots of appeal lie in any particular kind of application. So which tribunal you're appealing to, what the time limits are and whether you need leave. It is, as a practitioner, quite useful to know that stuff. So quite useful to learn it now. So this was an appeal from the Juvenile Court, which had been considering an appeal from the tribunal. So the original case was in the tribunal, that was appealed to the Juvenile Court, and that was then appealed to the court, and an appeal could only be brought on a point of law. So something had to have gone wrong with the application of the law. The appeal was brought by the convener against the department, and the department essentially is the Children's Service, I think, for the purposes of children law. Paragraph 12, the Deputy Bailiff talks about the importance of the welfare principle. So you need to know that's very important. And the welfare checklist, which we'll have a look at next. And the overriding principle. The judge refers to both English and Scottish authority. The Guernsey framework is not identical to Scotland's, and that is important, it's not. The Scottish system is useful guidance because your system was effectively modelled on it. But your cases do also refer to English case law. The welfare checklist is how we put that welfare principle into operation on the ground. Okay. So this is one of those checklists which is there to help the court exercise its discretion. Okay. So if a judge follows this, applies the welfare principle, applies the welfare checklist, it should end up in the right place. That's the plan. So the checklist is the child's wishes and feelings in the context of his age and understanding. So remember what we said about 12-year-olds. And obviously, if you've got a 2-year-old, their wishes are going to be difficult to interpret particularly closely. The age, gender, ethnicity, cultural background, language, religion, and other relevant characteristics of the child. So not all children are the same. They have different needs. They have different cultural needs as well. Any harm the child has suffered or is at risk of suffering. Now, harm is something which runs as a thread through the law because the court always has to be alive to the possibility that where there is a dispute, there can be harm. Okay, even where it's a dispute between parents, let alone before you get into the public law end of things. There is always the risk in any conflict of there being harm to a child. Harm does not just mean physical harm, it means all kinds of harm. The child's physical, emotional, and educational needs, how capable its parents are, the importance of contact, and the likely effect on the child of any change in its circumstances. So that's similar to the English checklist. When you're looking at the welfare checklist, we look at previous cases from time to time, and that's fine. It's difficult to say that many of them are authorities because when you're applying things like the checklist here, by definition, cases are very fact specific. The whole idea is that the reason you have that checklist is because your case, whatever it is unique. So what you could spend your life doing as a practitioner is finding every case that's come to court on a particular area. That's quite dangerous, because unless you can draw a principle out of them, cases on their facts are always distinguishable, always. So it's looking for the principles in the case law that becomes important. Case of Re T, that's 2010. So the law had just come in. That case concerned the change of a child's name. The law had not yet come into force at the time of the application, but had by the time it was reported, it would seem. But the case was treated as if it were an application for a specific issue order, and we'll see what they are. Case law was not of particular assistance, but did look at that as well as at the welfare checklist. So,
was it allowed?
I can't remember actually. The outcome normally isn't the important thing about these cases. What's normally the important thing about these cases is looking at the process the court has gone through to reach the conclusion that it got to. Do you see what I mean? Because the outcome will be fact specific. It is important, and it is a regular appeal point, and therefore your job to make sure courts don't do it is where they ignore the welfare checklist. They have to run through it. They have to run through it, they have to apply it, otherwise they're in hot water, because that is there to stop them getting it wrong. In the matter of C, again, you could tell the court was fired up. In this case, there does not have to be slavish reference to the child welfare principles and the child welfare checklist. It's quite clear that some provisions were considered by the judge. So the judge actually has to really set out how they have applied the welfare checklist. They don't slavishly have to go through every sentence of it if it's not relevant, but they do have to be able to explain why they've reached a decision that they have. And that's a core principle of judging, which is very important probably in family law more than in other types of law to a degree. People need to know why they've won and lost. So families have to be able to understand how the judge has applied the facts of their case to the checklist to achieve the outcome that they have. And it's the role of counsel to make sure that the judge has all the help they need in doing that. They have to show their reasoning. Jurisdiction, you need to be aware of Practice Direction 7 of 2009. The Royal Court basically has jurisdiction to do anything it likes. So the Royal Court has jurisdiction to deal with any children's case about anything. But as we've seen, the children law also created two new spanky shiny new tribunals. So often the first thing you might have to think about is which court you're issuing in, which court is going to get your applications, because we want to get it in the right court. Again, there are differences to the Scottish system, so be slightly careful. The law talks a lot about applications being brought in the relevant court. Okay. So the law tells you this application has to be brought to a relevant court, but it doesn't tell you in the law what a relevant court is for that kind of application. You have to find that in the practice direction. So the two sort of have to work together. And the relevant court will depend on what you are doing, so what the nature of the application is, and in some cases, for whatever reason, whether the parties are married. Okay. So important to be aware of that from a procedural point of view. What application am I bringing? Are the parents married? And what jurisdiction, which court has jurisdiction under the practice direction, or as a result of the application of it? The tribunal we've talked about, they make care requirements. Okay. Now, be slightly careful because that is not a care order. Okay. In England, we have care orders. Care orders are where children are removed from their families and put into the care of the state. So if you read about that in textbooks, that could confuse you. A care requirement is not that. A care requirement is an order that puts the child under the supervisory care of the states of Guernsey, purpose being to protect a child and promote its well-being, and they are there for a fixed period of time. The convener takes that case to the tribunal, so it's the convener who asks the tribunal to make the supervisory, the care requirement. Anybody can report anything to the convener that they want if they're worried about a child. And the tribunal is this establishment of lay people, panel of 3, drawn from the community. Their role is to consider whether children are at risk and whether intervention is required from the state. They're quite informal, these proceedings, allegedly. Well, that's what they're meant to be. In practice, how does it work? How do parents find them?
I don't know, because we don't go with them.
How do they report back though? Do they find them constructive or helpful, or?
It's a mystery to me.
Yeah, I think it's, and that's very much the impression I get from the law and what I could find out about it, that the tribunal is a bit of a mystery. You know, it's a foreign country, strange things happen there. It's a bit of a no-go zone for lawyers, and whatever they do is, you know, magical and mysterious, which always, as a lawyer and a control freak by nature, worries me a little bit, because it's quite serious stuff that they are doing. Now, to the extent that we can draw parallels, a care requirement is a bit like a supervision order in England. A supervision order in England is an order where a child is almost always living with a parent, but needs the support of the state to befriend and assist them so that they are good enough parents. In other words, they can't do it on their own. There is an element of risk there. There's something's gone wrong and this child is at risk of harm. But together we can fix it, guys. So we're going to, for 12 months, keep a careful eye on you, provide you with all the help you need, and set you off on the road to be good enough parents. It is similar to that, but don't get confused because they're not one and the same thing. And definitely don't get confused between a care requirement and a care order. Care order is English, care requirement is Guernsey. So that's one court, that's the tribunal. The juvenile court is a bit more familiar because there'll be lawyers there. There'll be a proper magistrate and everything. Okay. So this is the jurisdiction of the magistrate in proceedings involving a child. There is no panel, so they sit alone. Okay, single judge. The juvenile court deals with some matters that are referred by the children's convener. Okay. They can hear appeals from the tribunal, so where we think these lay people got it wrong, in relation to care requirements. And you can appeal it either because it's been granted and you don't like it, or because it's been refused and you think it should have been there. That's fine, either can be. It can hear applications for a secure accommodation order. I hate secure accommodation orders with a passion as a children's lawyer. They affront me. I don't like them. Secure accommodation orders are orders where a child is effectively imprisoned. They are detained in secure accommodation without the requirement that they have committed a criminal offence, or they may often have done, ostensibly on the basis that it is the only way for a limited period of time to keep them safe. Okay. There are very strict rules around when you can get secure accommodation orders, because if we didn't have very strict rules, it would be unlawful imprisonment, because this is imprisoning a child who ain't been convicted of nothing. Okay, so the juvenile court can hear an application for a secure accommodation order. It is an emergency provision. It is draconian. It is not very nice. The juvenile court is a relevant court to hear applications for an emergency protection order. An emergency protection order is what it says on the tin. it's a situation where you've got to do something, you're the department, or generally the department, and you've got to do something quickly to remove a child to a place of safety, okay, or to otherwise have an emergency protection order, because it is the only way of keeping a child safe, and you haven't got enough time to do anything else. Okay, again, draconian provisions. So the juvenile court can hear emergency protection orders, and it can hear applications for community parenting orders. These are more like the care orders that you get in England, where you read about children being in care. A community parenting order is made when it's likely a child will need long-term placement outside of its family. Only the department can bring that application, and they last until a child is 18 generally. So, important thing to remember, only the department can apply for a community parenting order, just as in England, only a local authority can apply for a care order. The juvenile court is a relevant court and can hear applications for a Section 17 order. These are the private law orders, okay? So these are the disputes between parents generally or other family members who can't agree arrangements for a child. Sometimes you'll be in front of the juvenile court, and sometimes you'll be in front of the royal court, where you've got these disputes between parents. I think I'm right in saying it depends whether they're married or not, generally, which is a reason, I suppose. I don't know quite why it's that way, but that's the way it is.
Juvenile court.
Yeah, I think the royal court hears married applications, isn't it? And the juvenile court unmarried. I don't know why.
The juvenile court, but you can't, that's the private court. Children.
Yeah. I assume that the reason they're married, they go to the royal, is because it's under the matrimonial causes division, and they therefore consider children of married couples to be part of their remit, I assume. The royal court will hear appeals from everybody else, basically. It can exercise all of the powers that the magistrate has, all the powers of the juvenile court, and it's a relevant court for the purpose of nearly every application you can make. Okay, so whatever application you can make, they can hear it. And it's the only court that can vary trusts. It's the same in Jersey, actually, only the royal court can vary trusts in Jersey. So the magistrates' court can refer a case where they think they need to, perhaps because it's particularly complicated. The royal court can refer an application to the magistrate, but only if it's not dealing with anything else. Sometimes what they do is they get rid of all of the stuff to do with the marriage and the finances and then send back down the kids, I imagine, perhaps. And when it's dealing with an appeal, the royal court can do pretty much anything it wants: confirm, reverse, vary, or substitute the decision of the magistrate or the juvenile court. Which court or public law proceedings will be instigated by the convener or the Health and Social Services Department, depending upon the order's sort. So the convener will bring an application for some orders, others will be the department. If it's a private law dispute, you've got to start in the right court. The royal court is going to be dealing with people who are married, and the tribunal people perhaps who are not. Again, that's Practice Direction 7 of 2009. All proceedings related to married parents will continue to be dealt with in the royal court where divorce proceedings are underway. So where there is a divorce, there is a royal court. Where parents are married, but there's no divorce, you can issue in the magistrates' court or the royal court. And remember, we looked at last time, there can actually be quite a long delay between even people separating and there being an actual petition. Maybe they haven't got a ground to bring a petition as yet. If you're not married, you're in the magistrates' court. If you're in Alderney and there are no divorce proceedings, or you're not married, you have to start in Alderney. And it sets out, as we've already said, which courts are relevant courts depending on the application that you're making. Helpfully, your practice direction has attached to it the forms that you use for most applications that you're going to make. And most applications seem to be done on the form CF1, don't they?
Yeah.
So pretty much any application you're going to be making is on that one form, which makes life nice and easy. And there's a parental responsibility agreement. We'll talk in a bit about what parental responsibility is. Appeals. I found appeals quite complicated in children's stuff when I was looking through your law, so I made a little chart, which seemed to me to be the easiest way of doing it. But please do run through and check it and compare it to your law and make sure you think it applies. I'm told by Adrian that there's at least one time limit which contradicts, so where there are different time limits and different laws for the same thing, so that as a matter of practice you take the longer period as being one that applies, so he tells me. So if you're appealing a Section 17 order, which is a private law order, so arrangements for a child, you go from the magistrates to the royal, juvenile court, Court of Alderney, or to the Royal Court, 21 days you've got to do that. Removal from the jurisdiction, so where you're taking a child to go off and live somewhere else or want to. Appeals lie to the Royal Court, 14 days. Care requirements, 21 days. Community parenting orders, 21 days. Secure accommodation orders, very tight time limits. I think I'm right in saying that you can't actually appeal an emergency protection order. You can't in Jersey, and it wouldn't surprise me. I'm not sure you can here.
Yeah, because you could, if they were successful, the interim order, care, community parenting order, appeal it, they just apply for an emergency. Yeah.
And I think once the court's made an emergency protection order, you can't appeal it, you can apply for its discharge. You can't appeal it. The idea being it's such an emergency that you can't have people faffing around trying to appeal stuff. You have to have something in place. Right, in the matter of C, again, I'm not quite sure if that's the same case but a different judgment, probably. It probably is a preceding judgment, actually. An appeal from a decision of the tribunal, they'd made an interim care requirement with a condition that the child live in the care of the children's service. See, I didn't like that. Because that doesn't look to me like a care requirement. That looks to me like a community order. Because if they're not living in the care of the child, the parents, but in the care of the children's service, surely that is what I would call a care order. I didn't like that, but that's what they had done. Family didn't appeal the actual care requirement, they appealed the condition. But again, if there aren't lawyers involved, how do they know to appeal these things? There were ongoing private law proceedings. You quite often get that. What you'll end up with is a battle between members of the family, and then the minister in Jersey, the department here, will swoop in and issue public law proceedings because it's all got truly horrible. So quite often you have them floating around the same courtroom. The Royal Court emphasised the importance of the welfare principle, and Article 6 and Article 8 of the European Convention on Human Rights. Right to a fair trial, right to respect private and family life. Okay. Emphasising for your exam purposes the importance of human rights to this area of law, the importance of getting procedure right. People have got to have a fair process, and the fundamental right to respect for their private and family life. I have not been able to identify where the tribunal applied the criteria in section 3 or 4 of the law, or at any time whether they considered the rights enjoyed by the maternal grandmother and C, and indeed the mother. They found that the process was flawed, and they set out in quite some detail what the appeal procedure was, which is quite useful. So it's worth having a look at all the different reports in the matter of C. I suspect that this in the matter of C was the subject of the later appeal, which is the other in the matter of C. But yes, that did worry me. It worried me that you had a lay panel making that judgment. And I know the conveners there. Don't worry. Okay. So that is the structure of your tribunal system. So the reason I've gone through that in quite some detail is because it is different. Because they decided, very creatively I guess, when they wrote their children law, that they were going to set up new courts and systems to administer it. So it's important you understand which tribunal hears which things and what it does. So we'll look in a lot more detail at what community orders are and what have you, but that tells you what the jurisdiction of these different courts and tribunals are. So get that into your head, flowcharts, whatever actually works for you, so that you can understand who's got authority to hear a case in particular circumstances. So we've looked at the welfare principle, which is important. Another principle, which is very important throughout the law is parental responsibility. A thing which actually governs the rights of every parent, but hardly any parents know what it is, or that it even exists, or that they don't have it. They assume that if they have a child, they have parental responsibility for it. Oh, alas not. So parentage and parental responsibility are very important concepts because they dictate who has the right to bring proceedings, what their rights, duties and responsibilities are to the child, when they have to be consulted and when they don't at all, and sometimes what the outcome of a case might be, so what role they're going to have in proceedings generally and what their options are. So it's a very important thing. What do you need to know? You need to know what it is. You need to know when people have it and when they don't. And you need to know why it's relevant to both private law orders and public law orders. But it is one of those things which is a complete mystery to most general members of the population. A lot of dads don't realise they don't have parental responsibility for their kids. And they don't know until they split up with the mother and the mother says you can't see them anymore and they have to find out about it. Okay, so shall we take a little break for a few minutes and then we'll come back and do parental responsibility. I do, as long as you don't, I don't know how secure it is, if you know what I mean. I don't mind at all. I don't know what they do around here. They seem to leave it unlocked and so it depends how attached you are to it rather than